Welcome to Unpacking the Pump Act, what employers need to know. I'm Sascha Mayer. I am the co-founder and chief experience officer of Mamava. We are based in Burlington, Vermont. And today I'm thrilled to be joined by Dana Kerwin and Liz Morris. Both are experts on this subject, and Dana leads strategy and solutions for employer and government relations at Medela, and she's also a very recent breastfeeding mom, so has that firsthand experience. And Liz Morris is the deputy director of the Center for Work-Life Law. Model legislation drafted by Liz and her colleagues served as the basis for the Pump Act, and she was a leader in the broad coalition that successfully advocated for this bill's passage. So we are grateful for Liz's work there. Our agenda today is we're going to check in a little bit on breastfeeding in the US, in general, the state of breastfeeding, what the Pump for Nursing Mothers Act is, what's staying the same from past legislation, what's new, what are those implications for both employers and employees, best practices for workplace lactation spaces to guide folks who are now working to be in compliance of this new legislation. And we will have time at the end for Q&A. A couple of housekeeping points to make here. We are very grateful for Ginger Smith, who is our ASL interpreter. Thank you for joining us, Ginger. And you will note that we try to use inclusive language in terms of gender, and as is Mamava's practice, wherever possible in the presentation. But when we cite other folks' research, we use terms that are used by the authors of those studies. I will hand it over to Dana.
Thanks, Sascha. And hi, everyone. Nice to be with you here today. I think, we wanted to start as we dive into information about the Pump Act with a look at the breastfeeding landscape, because the last few years have really had some major cultural events that have changed and influenced the way parents are thinking about breastfeeding. The first big event was, of course, the COVID-19 pandemic. And what we found when this arrived is that a lot of families with infants were really doubling down on their commitment to feed breast milk because of the known health and immunological benefits of that nutrition for infants. And so, as early as 2020, we were seeing some shifts and a deepening commitment to breastfeeding among families that were making that choice. Then we look at last year, and the infant formula crisis arrived, and families who were reliant on the availability of infant formula were suddenly really in harm's way in terms of not being able to find what they need, not having dependable access to food for their baby. And so families who were in the process of deciding whether or not they were going to breastfeed, more of them told us they had made the decision to feed breast milk or were planning to use less formula because of that scare. And then following on the heels of that were new guidelines that came out from the American Academy of Pediatrics around breastfeeding. So the new or updated guidelines continue to reinforce that breast milk is the best food for infants and really should be the only food for infants for the first 6 months of life. And then continued breastfeeding should be pursued according to the new guidelines for up to 2 years. So that's a year longer than what the guidelines used to say from the American Academy of Pediatrics. And all of these things have been influencing and changing the way families are viewing their decisions to breastfeed. Now, with this context and with this in mind, we certainly know what the guidelines say, but there's a lot of variation and difference when it comes to what's actually happening on the ground. And Sascha, I wondered if you could talk a little bit about the reality.
Yeah, so I think generally that is good news. And even the time that I've been working in the field, around 10 years, the percentage points of initiation of breastfeeding has ticked up to about 83% of new parents are at least initiating breastfeeding on day one. The challenge is if you do have parental leave, by going back to work at 3 months, that ticks down to about 69% of parents feeding any breast milk. And then, of course, it gets even more challenging at 6 months, where only about 24.9% of parents are feeding exclusively breast milk, and around 55% are feeding some. So that's the really point that the Pump Act is trying to close that gap to create more infrastructure and support for breastfeeding parents to actually meet that goal.
Absolutely. So I think to start, let's talk about what is the Pump Act. Maybe you've heard of it, maybe you haven't. But really what it is an expansion of the law under the Fair Labor Standards Act. So the Providing Urgent Maternal Protections, or PUMP for Nursing Mothers Act, was passed into law, signed by President Biden at the end of December 2022. And it extended workplace lactation protection to almost all breastfeeding employees across the country. And the important change here is that the amended law replaces Section 7R of the Fair Labor Standards Act. So the break time for nursing mothers law, which went into effect back in 2010 as a part of the Affordable Care Act, that law has been in place and required break time and a private space to pump, but it only applied to non-exempt employees or those employees eligible for overtime. And so there was a segment of the workforce that was completely excluded or unprotected by this law, and the Pump Act closes that gap. And I think before we dive into further details on the Pump Act, it's worth maybe noting, Liz, are there other new laws or protections around this kind of same pregnancy to postpartum space that our audience maybe should be aware of?
Yeah. Hi, everyone. I'm Liz Morris, the Deputy Director at the Center for Work-Life Law. Wonderful to be here and to see so much interest in getting things right with this new law. Yes. So in addition to the Pump for Nursing Mothers Act, another major piece of federal civil rights legislation that directly impacts new parents also passed, and that is called, excuse me, the Pregnant Workers Fairness Act. And that law goes into effect on June 27th of this year. And essentially what it does is it gives employees a right to receive reasonable accommodations that they may need for pregnancy, and related medical conditions, which includes lactation. So this is modeled on the ADA, and it basically gives a right to reasonable accommodations to nursing parents. And just like the ADA, I'm sure most of the HR folks and employers on here are familiar. The accommodation has to be provided unless providing the accommodation would impose an undue hardship on the employer or significant difficulty or expense. And so really the rights of lactating workers have expanded with the Pump Act and with the Pregnant Workers Fairness Act substantially in December 2022.
Thanks, Liz. That's great. So a bit of a belt and suspenders, if you will, on protecting nursing moms, which we love. So let's dive into the law a little bit more. I think it's useful to understand exactly what the law says, and this language came from the Department of Labor directly. And it says that the Fair Labor Standards Act requires employers to provide reasonable break time for an employee to express breast milk for their nursing child for 1 year after the child's birth. Each time such employee has need to express the milk, and employees are entitled to a place to pump at work other than a bathroom that is shielded from view and free from intrusion from coworkers and the public. And so when we look at this, I think, one thing to consider here is that each of the items that are bolded, and we'll do a deeper dive into each of these pieces, kind of break down what employers are going to be held to and what employees are going to be expecting as they come back to work. So let's kind of dive in and talk a little bit about what elements actually stay the same. So as we mentioned, this is an expansion of the existing law. Reasonable break time, that has always been written in the law and continues to be a requirement. The next one is around accommodations for 1 year following the birth of a child. And this is one, Liz, I think this is a good opportunity to maybe get some insight around what this language is intending to represent, because there's maybe some interpretations around scenarios that are less common. If we think about a woman who's experienced a stillbirth tragedy, or maybe there's somebody who has given birth as a surrogate and maybe wanting to pump for that baby. Can you speak a little bit about what 1 year after the birth of a child might mean and what is covered or not covered?
Yeah, absolutely. So in addition to the language about 1 year after the birth of a child, part of the requirement is that the employee be expressing the milk for their nursing child. And so, courts are going to, and perhaps the Wage and Hour Division of the Department of Labor are going to interpret what that means. However, in the tragic event of a stillbirth, this Pump Act would not apply, given that standard of their nursing child. And in the case of surrogacy, there is some precedent that it also does not apply. Sort of the construction of their nursing child. I think that's up for debate, what that means. But really important to keep in mind, again, that the Pregnant Workers Fairness Act covers people who are surrogates and who have experienced loss. And so those folks, even if the Pump Act doesn't apply, would have rights from this other new law that's going into effect in June.
Right. The next piece that stays the same is that a space must be provided that is shielded from view, free from intrusion, and is not a bathroom. And Liz, I'm going to throw the ball to you again on this one, because I think there's been a lot of discussion that I've had and with others around what free from intrusion means, right? I mean, some people are saying, well, that means it has to be a door with a lock. But there's other arguments. Well, no, if you hang a curtain, that's good enough. And so I think this is an interesting area that we're going to be navigating together, and would love to know from where you sit how this might be interpreted.
Yeah, absolutely. And I think you're right. This is something that's going to be navigated. And by that, I mean interpreted in the courts and and perhaps by the Department of Labor. That said, from sort of the general context of how these things play out and how the Obama administration interpreted the meaning of free from intrusion when this law initially passed in 2010, it really depends on the circumstances. So where it's practicable, a room should be made available, but there are many circumstances where that just isn't practicable. And so in those cases, another space with some sort of privacy mechanisms should be made available. So that could be curtains, partitions. Also important to keep in mind that windows should be covered. Employees should be allowed to shield themselves from any cameras that may be operating, since it could be a multi-purpose room. There could be a camera like in, the manager's office at a fast food restaurant or something like that. And of course, employers cannot completely control the actions of all other people who may barge into the room, particularly like members of the public. But there are, of course, reasonable steps that can be taken to minimize that risk. If it's feasible, a lock is, of course, preferable. But things like placing a sign so that folks know that, the area is in use by a lactating employee can also accomplish the goal. And I think it's also important for employees to keep in mind that if an intrusion, employers should keep in mind that if an intrusion does occur, it's the employer's responsibility to respond in a responsible way to prevent it from happening again in the future. For example, if the intrusion is on the part of an employee, another, a coworker, counseling that employee about their behavior, for example.
That's a very good point. Free from intrusion has to actually function, even however it's interpreted.
Right. Yeah. And a lot of this is sort of case by case, or workplace by workplace, depending on the circumstances.
Context is everything.
Right.
Great. And the last piece that stays the same is that there is a clause that allows small employers, those with 50 or fewer employees, to not be required to comply if they can prove that complying would be an undue hardship on their business. So now let's take a look at what's new. So those are the things that stayed the same. In terms of what's changed, the first and really big component is that this is protecting more people, and it's protecting a lot more people. Coverage is now extended to 9 million more women of childbearing age who may be not eligible for overtime, but are now still protected by the law. And Sascha, I wonder if you can speak a little bit to what this means practically and culturally for all these newly covered members of the workforce.
Sure. I think this is really interesting because you think of breastfeeding parents in education, often female dominated, especially in primary schools. And often of childbearing age. So all of those teachers, my husband is a middle school teacher. He's had many colleagues who have had to sort of navigate what it means for them to breastfeed. They often have the value set to want to breastfeed. And then you think also in the healthcare professions in terms of salaried nurses and doctors and other healthcare professions, and those unique environments of education facilities and healthcare facilities, and how now those employers are going to have to figure out in those time and space compressed environments how to make this work. But I think it's a very good thing because it's a huge demographic of people.
Perfect. The next big new piece of the law is this right to sue. So employees are now able to file a private lawsuit against an employer for non-compliance. And we'll talk in some more detail about what that means a little bit later in our session today. The next thing that the law has added is clarification around how compensation works. So previously, the law protected employees who were eligible for overtime, but it wasn't clear whether these breaks were paid or unpaid or how that was supposed to work. And so the new law now has made it clear that if employees are not relieved of their duties while they're pumping, then that break counts as time worked, which means it must be paid, and it means that that time counts toward any overtime calculations. So if an employer wants the break to be an unpaid break, it's important that they ensure their employee is relieved of all duties or responsibilities for the duration of the break. And then the last piece tied to that right to sue is just the timeline for enforceability. So the law was signed on December 29th and it went into effect immediately. This is now the law in the country today and has been since the end of December. However, the right to sue and the enforceability goes into effect on April 28th of this year. So in just a couple of weeks, that piece will be effective, and employees will have the right to sue. So let's take a little bit of a deeper dive on these changes. The first thing is around break times. So the law says that employees may take a reasonable break each time they need to express milk. It's important for employers to know that you cannot deny a break, and you can't define the duration of that break. So one employee may need to pump twice a day, and another employee may need to pump 4 times a day. And these breaks need to be made available at the employee's need. And some people may pump and only need 20 or 30 minutes for a break. Another employee may need 45 minutes for a break. So that reasonable time will vary from employee to employee. And it's important that employers understand you can't say you only have 20 minutes. The break needs to be reasonable and accommodate the needs of the employee. The next thing is that there's been talk about what the space requirement is, and the fact that the space needs to be functional and will be evaluated as an acceptable space against this idea of functionality. Now, there aren't specific standards for what the space has to have, at least not written into the law. But as employers are trying to think about what they want their space to be like, considerations for what makes that space usable for pumping is really important. Things like having a surface to place a pump on, having access to an electrical outlet so that an employee could plug their breast pump in, and even things like proximity of the space to the employee's workstation. If somebody has to go to a different building or cross a campus to get to a pumping space, that may not be considered functional for them. And then there's availability. So in that same idea of being able to get to the space, it is also being able to get into the space. So if, especially in a scenario where an employer is maybe using a multi-purpose space, such as a break room or a wellness room, it's really important that a pumping employee be able to access the space when they need it. And that you wouldn't have, say, a wellness room occupied for another purpose at the time that an employee needs to get in there and pump. So availability is going to be an important consideration. And then that privacy piece, and Liz, you covered this, and I think it's exactly right. Thinking about what privacy looks like, and again, what works in the context of your environment. The space cannot be a bathroom. It must be shielded from view, and that includes cameras. So I think that's a really important one. It's not just a view of anybody who might be sitting in the area, but also any security cameras or surveillance that may be in place, and free from intrusion by coworkers and the public. And then finally, it's worth calling out this note around retaliation. This has been spoken about, and I think important to reiterate that retaliation against a breastfeeding employee is strictly prohibited. And this can kind of take a couple of forms, and I think important to note. One is certainly if an employee files a complaint or files a lawsuit, an employer may not retaliate against that employee. But it's also would be considered retaliation for an employer to make an employee's job, to penalize them in ways with their job for breastfeeding. Say, if somebody says, I have to walk too far to get to the pumping space, and their employer says, well, then you're going to have to do a different job and it pays less. Or you're going to have to move to a night shift instead of your regular shift in order to be able to pump during your workday. Those would be considered things that could be viewed as retaliation and wouldn't be allowed. So let's jump into the right to sue for a minute. So we talked about this being a new part of the law. Again, effective April 28th, employees may file a lawsuit against their employer if they are not complying with the new Pump Act. Within that process, if employers are violating the private space requirement, the employee needs to notify their employer first of the non-compliance, and then the employee must wait at least 10 days before they file a lawsuit. So it's important that employers address those issues as soon as they become aware, but know that an employee who is experiencing an issue would be expected to notify you. The other thing to note is that that notification requirement is only true of the space. So violations of, say, break time requirements, if an employee is being denied break times, they wouldn't necessarily be required to do a formal notification. And then finally, from a remedy perspective, remedies can include things like employment or reinstatement, promotion, or monetary damages like lost wages, emotional distress, or the cost of a lawsuit or attorney's fees. And I wonder, Liz, if you can take a minute and just provide some insight around what lawyers may be thinking about in terms of remedies when they're looking at this.
Yeah, so the available remedies is something that, you know, we already know a bit about, because it's remedies that are available for other violations like retaliation under the Fair Labor Standards Act. So there's a whole body of law interpreting it. And the damages can be substantial, even sometimes including punitive damages. Now, that would be rare in a case where there was a real willful sort of violation. You know, somebody asked for the accommodation and they were fired. But you know, that kind of thing exists. And then when it says attorney's fees and lawsuit costs, that's not just the employer's attorney's fees and lawsuits costs. That's also the attorney's fees and costs of an employee who prevails. And so you know, these provisions go into effect on April 28th, and so important to really get a handle on this before then. And I also just want to make a point about the notification. If I just want to caution employers and HR folks from sort of relying on, oh, the employee is going to have to file some sort of formal notification, so I will be aware that, you know, this is happening in the HR department and I'll be able to correct it. If, you know, a supervisor makes clear their intention that they don't intend to provide space, that's actually a situation where the employee wouldn't even need to notify you. Also, you know, not providing a space or an adequate space may be a violation of the Pregnant Workers Fairness Act, and there's no violation, there's no notification requirement in that circumstance. And so while it's true that an employee who doesn't have adequate space does have to notify and wait 10 days before they can file a lawsuit, I wouldn't like depend on that. I would make sure that, you know, you folks in HR are following up and making sure that everything is working out for the employee who's made the request, and training the managers who are going to be responding directly to these requests. Because if they say, no, we're not doing that for you, there's no need for the employer to, the employee to notify. And, you know, notification could be telling their manager that something is wrong. So it doesn't have to be like a written letter. So just something to be aware of and be careful about.
Right. Thanks, Liz. I think that's helpful. So what does this mean for workplaces? I think it's important to remember the POMP Act is establishing a floor here. Or essentially the minimum standard for workplace lactation accommodations and a legal baseline for employers across the country. But beyond that, there are a lot of additional considerations to creating supportive workplaces. So Sascha, I'm going to toss it to you to talk a little bit more about that.
Sure. I'm going to be speedy here because we're getting lots of great questions. I want to make sure we have time for it. So just a reminder that there are actually lots of municipalities and other states that have even more rigorous legislation. So the law is that you go with the strongest protection. So that might be that might include the threshold for exemption being lower, example, 25 employees instead of 50. Workplace protections that go beyond a year. For instance, here in Vermont, you actually get 3 years protection to breastfeed and for the break time. And then the requirements around the lactation spaces, they may be more rigorous in some locations, including, specifying an electric outlet as an example. And then for who is covered under certain populations, the Pump Act does not stipulate this, but for instance, students in some municipalities, incarcerated people in some places may have more rigorous protections for lactation accommodation. Again, we covered a bunch of these already. Ideal is that private room with a lockable door so that there is no question about that free from intrusion. Think of these spaces as being more like a kitchen. You are preparing food for a new human. It's always been amazing, to me in the work that we do of how little design consideration and infrastructure has been put in play for this fundamentally human function. We have designed for everything in this world, but so little around support for breastfeeding and pumping. Again, Dana mentioned this, close to where the employee works. You don't want to have someone, for instance, on a manufacturing floor that has to walk 2 football fields away to access a lactation room. And then easy autonomous access. We don't want to have the employee jump through hoops to actually get access to rooms, go to a supervisor to get a key. The point is to make it easier for breastfeeding parents to be successful. And then all the other nice things to think about, you're disrobing and attaching a breast pump. A mirror is nice when you need to put yourself back together. Having a hospital grade, a multi-user breast pump in rooms creates an excellent efficiency for employers in terms of the breastfeeding parent only needs to have their flanges and their pumps, and a hospital grade pump actually allows more breast milk to be expressed faster, and also the employee doesn't have to be schlepping around so many parts. Pumping supplies, sanitation, personal storage, making sure that the room is comfortable. Breastfeeding is both physiological and emotional, so that reflex of letdown is important to be feeling safe and comfortable and supported. Again, running water is in proximity is nice, and then a microwave for steaming and cleaning breast pumps, and a refrigerator are also great amenities to include in a lactation room. This is the data around what the NIH recommends for lactation spaces. I can say it is not nearly enough, but we thought we would include it here. I want to give the example of my own business. When we were first starting out, we had 7 employees, 2 gave birth in May. We needed 2 lactation rooms because we worked a 9-to-5 schedule. The NIH recommends 6 lactation spaces for 1,000 employees. Any gender in terms of that employee mix, and then for smaller businesses, 1 for 100 employees. Again, if you have 4 to 6 pumping employees, you're going to probably need to understand the overlapping schedules, and that you need to accommodate all of them within whatever the shift looks like. And for people who aren't as familiar with breastfeeding, parents typically need to do it every 3 to 4 hours, depending on kind of where they are in that cycle of anywhere from newborns to 6 to 9 months. And then breastfeeding typically needs, an average of 30 minutes by the time you're setting up your equipment and pumping and then cleaning up. That's what you can expect for the employee to need that break time. Again, really, really important to be front-footed around supporting breastfeeding. You want to have these tools in place before maybe even one of your employees goes out for leave. It should be part of your policy, something you discuss openly with employees and managers. We're a community that wants to support lactation. So a lactation policy should include a statement of support for your breastfeeding employees front and center. It's a celebration. You're growing, again, new humans. So this should be a really positive thing and not something scary to talk about. Information about a nursing employee's rights under the law, both the federal law and your local law, should be included in that document. Clear protocol for how breastfeeding employees will request access to the space, and obviously managers and that employee should know about that and be comfortable. There's nothing more intimidating than going back to work after having a new baby, and then also navigating that breastfeeding journey. Make it easy on your employees. Guidelines and how the space is used. So we know that there are many wellness rooms out there. Clarify what is a solely breastfeeding space, who uses it when, and that's going to make everything run much more seamlessly. And then just in general, a communication plan for how you're going to inform current and future employees. At Mamava, of course, it's one of the first things we talk about with all our employees, and we want to make it a welcoming environment. It should be right there in your benefits and in your employee manual. So some additional resources here. Again, we're going to be sharing this deck with all registrants, but excellent resources for you to dive a little deeper. I want to thank everybody so much. And now we're going to open it up to questions.
Okay, so we have 53, the number keeps popping up, questions. So I think a lot of it is probably going to be repeat information. What I'm going to do is just try to sort of go through these as quickly as possible, answer the ones that I'm able to, pass it to Sascha or Dana for questions that I'm not able to answer. And we can stay on a little bit longer, and this is being recorded. So if you have to jump off, of course, understand that, but we'll hang around a bit longer to answer as many of these questions as we can. We're up to 55 now. So the first is, given your involvement in drafting the legislation, can you share what the law's provisions are in cases where providing a lactation space is physically impossible or creates a severe financial hardship for the company? This is a situation where there is, it's a retail location. And so there's a concern that, taking that this would require sort of taking down shelving or removing merchandise from the store. So this question goes to a few things. First of all, for employers that have fewer than 50 employees, there is an undue hardship exemption. And so if it is true that there would be a significant difficulty and expense, which is considered in light of the employer's overall resources, the type of business operation, their revenue, if there's truly a significant difficulty or expense, then the employer is excused from complying in a particular case or in a particular instance when that undue hardship arises. So here we know that there's a retail institution. Are we talking about the Gap, or are we talking about, a mom and pop where really mom and pop are, running a small store with one employee? And that will really dictate what solutions are possible. For example, if this is the Gap, perhaps a changing room with a curtain can be used when the employee needs it, with an extension cord for the pump. Or perhaps in the shopping mall, there's another lactation space or a pod that can be purchased by multiple of the retail locations, so that employees and perhaps even customers who want to enjoy their shopping experience can go there. I think what that sort of speaks to is that there are so many creative solutions available. I think when people hear, oh, you have to provide lactation space, people think, well, I don't have a room in my in my workplace, and so it's not possible. But there are so many creative solutions. Mamava is providing one of those solutions, and there are many others. We've seen pop-up tents being used in agricultural fields. So there are many solutions available. The next question is, some of it is about the data that relates to women returning to work, but I would suggest taking a look at the slides and looking at the initial study that's cited there. Is reasonable break time to pump in addition to normal break time is a next question. So yes, so an employer, when we're thinking about break time that already exists, an employee may use their break time that already exists to pump, and that may be their preference so they can get home to their baby sooner. But it may also be true that it's a 10-minute break and they may need to use the restroom, or maybe a 20-minute break and they need to eat their lunch, and so pumping during that time isn't possible. It may also be true that the time of day that the break is given just doesn't work with the employee's pumping needs, and so it's not possible to use that break. The employer cannot force the employee to use a pre-existing break, although if it is possible for the employee to do so, that is probably going to be their preference because they want to get, again, home to their baby. The break time that is reasonable, yes, might be in addition, or likely will be in addition to normal break time that's being provided. Also keep in mind that if there are paid breaks that are normally provided to employees, just because somebody is pumping and pumping breaks can be unpaid under this law, it doesn't mean that all of a sudden the person who is using their normal break time no longer has to be paid. That would be, for example, retaliation or discrimination to take away the pay that they otherwise would have been receiving during that break time because they're using it for milk expression. Another question, what are the updated accommodations for pregnant workers? So I mentioned earlier, the Pregnant Workers Fairness Act gives the right to reasonable accommodation. It's modeled on the ADA, and so accommodations have to be given so long as they can be without an undue hardship. It applies to employers that have 15 or more employees, although many states have their own Pregnant Workers Fairness Acts that's applied to smaller employers. In the context of lactation, what these accommodations can look like, for example, is maybe having break time and space to pump for 2 years, as the AAP recommends, instead of the Pump Act kind of cuts off at 1 year. Maybe a situation of surrogacy, as we mentioned earlier. There could also be things other than break time and space that somebody may need for breastfeeding that can be reasonably accommodated without an undue hardship. So for example, maybe somebody needs to who's telecommuting, wants to directly nurse their child at home. There's, situations where somebody may have developed some sort of complication like mastitis, which is basically a very severe breast infection that can result when somebody doesn't get to express milk on as needed, which is why the Pump Act's very important. So maybe somebody has mastitis and they need time off to go to a medical appointment. That's an accommodation that could be provided. Maybe somebody has a need to change their work uniform. That's a restrictive bulletproof vest, for example, and that's inhibiting their milk supply. So, there's a world of accommodations, just like under the ADA, that somebody may need, but mostly it'll be around break time and space when we're talking about lactating workers. Okay, I'm going to actually come up from the bottom with these questions because it keeps flipping me to the bottom and I'm losing my space. From a facilities perspective, I'd like to understand if there are lactation spaces, implications we should be aware of. I'm Sascha, I know you're the facilities person, although this question, I'm not really sure what it means. It's a bit vague, but maybe you understand it.
Yeah, I'm not sure if I do understand it, but again, the floor is pretty low for what an actual lactation space is. And all of the standards for facilities, for hourly, for salaried, that we put forth in the webinar hold. So it can be a freestanding space, for instance, which is what we make at Mamava, and it also can be a built-in room.
Okay, and then another question about whether there is a model that has running water accessible.
At Mamava, we do not make a unit with running water, part of our design is that it can be in proximity and convenience of the breastfeeding parent versus proximity and convenience of the plumber. So that's been deliberate. Also, of course, there are efficiencies in cost when you eliminate the plumbing. We do highly recommend that it is placed, near running water, but it's not a mandate of the law and not something that we offer at this time.
And I will add, there are a lot of options for cleaning that don't require water, because a lot of parents who pump outside of the home don't always have access, or maybe, they're looking at a public bathroom, which isn't always a desirable source of water, even if it's there. And so I think that, for spaces where clean running water isn't readily accessible, thinking about providing pump safe wipes, cleaning spray, a microwave that allows for sanitizing parts. Those are all great alternatives.
Thank you. Next question. We have a small room with a door located in a women's locker room. The locker room is open with bathroom stalls. Would the small room work? Obviously, I haven't seen a picture of the small room, but I assume it's like free of mold and, relatively clean and can fit a person. In which case, yes, that sounds like it would be acceptable. There's no mention of next question. There's no mention of refrigeration. Can you advise on that? So an employer isn't required to provide, and I assume that I'll advise on that on the law and then pass it to Sascha to advise on that in terms of the functionality. Under the law, there's no requirement that an employer provide a refrigerator for a lactating employee to store milk. However, if an employer is providing a refrigerator for other employees to do other things, like store, their lunches, then, not allowing the lactating employee to use the same refrigerator because it's related to lactation could be discrimination under a law called the Pregnancy Discrimination Act that prohibits discriminating against lactating employees. Also, in order to sort of be functional, the employee and to provide, the requirements of the Pump Act, the employee should be allowed to carry their own refrigerator, a personal cooler. And even if an exception needs to be made to what the employee is allowed to carry, that should be allowed because they have to have a way to store the milk, and the employer has to provide sort of a safe space for the employee to be able to store it. Now that might be somebody's office or a locker or something, but the point is, exceptions to rules against bringing personal items would have to be made to allow the milk to be stored, as well as a safe place for the pump to be stored. And under the Pregnant Workers Fairness Act, depending on all the circumstances, it may also be a reasonable accommodation to provide a refrigerator. And so that'll be sort of fact specific. Turn it over to Sascha for the functional response.
Again, fun fact, actually breast milk is pretty stable at room temperature for a number of hours, but it's easy enough to have folks have a cooler that they can keep with them. Our units do come with the ability to plug in a small, like dormitory size refrigerator. I think it's really important to think of the context with which the lactation room is being set. For instance, if you have a lactation with a refrigerator and it's single use and the door is locked and a parent gets called to go pick up their baby and the person is using it, then it creates some complexity there. So every scenario is different. Again, we offer units that have a refrigerator, but you should really consider the specific context. I wanted to mention too, a multi-user room, we haven't touched on that today, is totally fine under the letter of the law with sort of privacy drapes. And we do see those as well, where you might have space for multiple moms who need to use a breast pump in a large type of work environment.
And I'll also just jump in and add a note here. While the federal law doesn't mandate refrigeration, certain state laws might, and California is a good example of one, that they do actually require that breastfeeding employees have access to refrigeration or a cooler provided by the employer. So again, understanding what the law is where you are is really important. The Pump Act is just really the bare minimum.
Yeah, good reminder.
Yeah.
All right, how are we doing for time here? I want to make sure we honor our guests' commitment and Ginger, who is working hard. Thank you, Ginger.
Yeah, I told
questions?
Megan that I could, sorry. I told Megan that I could keep answering these questions. I think that they're really important, but
Okay.
we'll leave it to you, Sasha. But to the
Great.
extent
Well,
it's
so we'll
not
go.
burden
Yeah,
on me,
no, we're being really generous with your time. So let's we'll go till we have another 5 minutes. We'll go till 3 o'clock Eastern time.
Okay. So another question, super important to understand, as this extends to non-exempt employees now, isn't this functionally paid breaks? So important to know that employees who are paid on a salary basis, regardless of the number of hours they work, shouldn't be docked their pay because they are taking pumping breaks for many reasons. First of all, it's retaliation because you're not docking the pay of non-pumping employees because, you know, they're going to the bathroom or doing whatever. You're not counting the number of hours that people work. So it's very clearly retaliation. It also could be an FLSA wage and hour violation, but I'll leave that aside. For another note on the pay, in addition to having to pay people under the FLSA for all hours worked, having to pay them minimum wage and overtime for all hours worked, it's important to know that there are some state laws that require paying people during their lactation breaks. So Georgia, Illinois, and Minnesota, I believe, are the states that require that. So important to keep that in mind. The law requires 1 year until the child, next question, the law requires 1 year until the child is 1 to pump. You mentioned up to 2 years. Sorry, what protection is that under? First of all, could be under your state law, but also under the Pregnant Workers Fairness Act as a reasonable accommodation. Many employees nationwide will be entitled to longer than 1 year. Is it okay to have the lactation room on the 3rd floor or on the 4th floor when you're on the 3rd floor and have employees take the elevator? Yeah, unless there's something that I don't understand about that seems reasonable to me to have somebody go in and take an elevator.
I think there's a really strong argument for those folks who are lactivating for themselves here about building capacity, which creates efficiencies in a work environment, right? So again, you might have 0 breastfeeding parents in a business, and then you have a baby boom, and then you have 4, and you just need that accommodation. So maybe 1 lactation room doesn't cut it, and there are more flexible ways. Again, you can flex up with an additional space. That's something that we try to solve the problem with our units, but even commandeering a dedicated additional lactation room for the time that the business needs it. But I think thinking of it that way is it's efficiencies for the business. If your employee isn't spending a ton of time, lugging their pump around, getting access to a room where too many people are using it, that's a problem for business, and it's not good business.
There are 2 super important questions. There's so many important questions I want to get to these 2 really quickly. May an employer request documentation for lactation breaks? There's no official guidance on that, but I would take the position that no, if somebody tells you that they need the break time because they're nursing, then the break time needs to be provided. And also work trips and work-related events off-site, super important, especially with telework. It is the employer's responsibility, regardless of where the employee is located, to ensure that the employee has the break time and the private space that they need. So that means that if, one thing that we see with teleworking employees, of course, most employers are doing the right thing, and this isn't an issue, but we are seeing an issue pop up in some situations, which is that the manager of the employee is like, well, you're at home and your baby's at home, so you can't take any breaks. And there's sort of a hostility that develops when the person says, I need to take breaks to pump milk. And so telecommuting employees are equally entitled, you'd be surprised at things that we see. Telecommuting employees are equally entitled to take these breaks. And obviously the space is something that they can arrange in their own home, but they should be allowed to turn off their cameras. We've heard that people are being told they can't turn off their cameras. When somebody is traveling for work, it is still the employer's responsibility to ensure that they have a lactation space. So if they're going to meet with a client, for example, it's the employer's responsibility to facilitate the conversation with the client that the person is going to need breaks or a space. And so the burden shouldn't just be left unilaterally on the employee to arrange all of that.
And I think a finer point in that, correct me if I'm wrong, Liz, also is, let's say you are a company that outsources custodial services and you have, more than 50 employees, but 4 of those are working, let's say, in a mall. Your responsibility is that those employees are having lactation accommodation in the place that they're working. As a complex example that does actually pop up once in a while with us. All right, so we are at 3:00. These have been tremendous questions. I'm sure we have many more. Perhaps we will be able to schedule another of these webinars again soon. Dana and Liz, thank you so much for all your work around this issue. Liz, for getting this Pump Act over the finish line. It's changing a lot of people's lives. Ginger, for being a beautiful communicator today. And again, we will be sending the link to all of the deck that we went over today and the recording as well. That should go out, if not today, then tomorrow. And
I'm sorry, Sascha. That was a beautiful wrap up, and thanks. Can I just say one thing? The Center for Work-Life Law, the organization, I'm sorry, Sascha, the organization where I work, we have a free legal helpline, a confidential free legal helpline for employees. We also will assist employers who are trying to comply and do the right thing to understand what their legal obligations are. We contract with somebody who represents employers to provide that. And so, please feel free to reach out to the Center for Work-Life Law. To me, I'll get you in touch with the right folks if you're trying to navigate this. Sorry, Sascha, your wrap up was beautiful and I interrupted it, but thought that was important to let folks know.
Thank you for that reminder. All right. Thanks, everybody. We will be connecting again soon.